Most political scandals don't begin with a sealed envelope or a secret meeting or some sort of cinematic act of corruption. Most often, they start when a society forgets the difference between legal compliance and public accountability. A public official can still follow the rules and, through their actions, demonstrate that the rules are still inadequate. A prime minister can still comply with the law and leave concerned citizens with concerns about the architecture of accountability and realize that the rules just aren't strong enough. And that is the question we're trying to examine in this video today. And I want to be very clear that this video is not a partisan attack. I'm not calling out a single individual. In this case, we're going to use the example of Prime Minister Mark Carney. And I'm not going to call out the Liberal Party specifically. This is a nonpartisan issue. Our exploration in this video and the topics we're going to cover today is a larger exploration that's greater than any man or single party. It is also not an argument that anybody who's wealthy or successful shouldn't run for public office. After all, wealth does not make ethics irrelevant just because it's in the political structure. But just because someone or anyone is administering the state doesn't suspend the rules for accountability. For roughly the last half century, Canada has suffered with an ongoing problem. How do we prevent the enormous power of the office of the Prime Minister to not be entangled with private interests, or political advantage, or corporate influence, or old institutional loyalties? This problem didn't begin with Mark Carney or Justin Trudeau, or even predecessors to them like Harper, Chrétien, Paul Martin. It's been going on for decades. The names of the parties change over time, but the question remains. When public power can move private wealth, who watches the people that wield such power? Under Canada's Conflict of Interest Act, certain public officials cannot hold certain controlled assets unless they divest them. Controlled assets are those kinds of assets that could be affected directly or indirectly by public policy or government action. And these could include self-directed registered plans, commodities, stock options, or publicly held securities. The Act permits divestment through either a arm's length sale or by placing them into a blind trust with certain statutory requirements. This all sounds reassuring. The phrase blind trust even has a deep psychological effect because it suggests distance and neutrality. It suggests that knowledge has been removed, that temptation has been neutralized, and the public can stop worrying. But the word blind works more rhetorically than pragmatically. Section 27 of the Conflict of Interest Act says that the reporting public office holder must not have management or control over trust assets, and that the trustee must not seek or accept instructions from the office holder. It also says that the trustee cannot provide any information other than what is required for public disclosure and periodic reports on the trust's overall value. That is a safeguard, but it's not the same thing as ethical invisibility. A blind trust does not erase information or knowledge or the awareness of what assets may be placed into that trust or what the effect of policy is on those assets. And certainly it doesn't eliminate the possibility that government policy, and I mean broad policy, may not affect the value of those trusts indirectly. And that is the blind trust problem. It's not that blind trusts are useless per se, but they're treated as being morally conclusive. They are only tools for compliance, not some metaphysical cleansing ritual. In Mark Carney's Public Disclosure Index filed with the Office of the Conflicts of Interest and Ethics Commissioner, lists assets divested into a blind trust under Section 27 of the Act, which included shares of Stripe, shares of Partners Value Investments, options and deferred share units of Brookfield Corporation and Brookfield Asset Management, a notional long-term incentive plan in the Brookfield Global Transition Fund, and securities held in a third-party managed investment account where the disclosure states that the Prime Minister did not control or direct the selection of the investments. Again, The point isn't that this is illegal. The point is that it's asking the public to accept a very specific set of facts. It's asking the public to accept that because the assets have been placed into a blind trust, and because there is a conflict of interest screen that's been implemented, that conflict has been managed. But managing conflict isn't the same as eliminating it. And that is a major difference. The parliamentary record shows that Prime Minister Mark Carney placed those assets into a blind trust. And a conflict of interest screen was established to prevent him from being aware of official decision-making matters or decision-making processes surrounding specific companies, which included Brookfield Asset Management, Brookfield Corporation, and the companies that are owned by them. That same committee report suggests that the screen was implemented on July 10th, 2025, and it lists 103 entities. Now, was Carney cleared by the Ethics Commissioner? If by cleared someone's referring to a full audit and a report, an exoneration of the alleged wrongdoing, then no. If by cleared somebody means that the blind trust and the conflict of interest screen was approved and accepted by the compliance measures in place, then yes. In fact, the Liberal dissent in the House of Commons Ethics Committee stated that the blind trust and ethics screen were compliant and approved by the Conflict of Interest and Ethics Commissioner, and that the Prime Minister's use of a blind trust had been deemed appropriate. So it's not that Mark Carney broke the rules. The problem is that Mark Carney followed the rules, and that's why it deserves a deeper level of scrutiny. Legal compliance is not the same as public accountability. And the main weakness lies in Canada's definition of private interests. The Conflict of Interest Act says that a private interest does not include an interest in a decision or matter that is of general application, affects the public office holder as one of a broad class of persons, or concerns official remuneration or benefits. Prime ministers do not pick winners by selecting one company at a time. They shape broad policy in climate, industry, taxes, basically the investment and industry ecosystem in the country. And such broad policy can still create private benefit in the most black and white terms. A generally worded policy has the potential to create asymmetrical or concentrated gains. A sector-wide tax credit can benefit firms already poised to use it. So when the law says that broad class matters are outside the definition of private interests, we should be paying attention and raising the flag to draw attention to this. A House Ethics Committee report in the Conflicts of Interest Act examined this issue directly. It noted that Section 2's definition of private interest is significant because it affects the rest of the Act. It also summarized testimony that broad class and general application exclusions may allow senior officials to participate in decisions that can materially benefit them, even if it's an economy-wide decision. The committee recommended narrowing that exclusion for prime ministers, ministers, and parliamentary secretaries, where financial interests are so extensive that a foreseeable, reasonable, and material benefit may result, even from a broad policy scope. And that recommendation gets close to the real issue. It's absurd to claim that every policy is absolutely corrupt. The issue is whether certain private financial interests are so entangled, so complex, and so connected to broad government policy that the ordinary rules are not enough. And at this point, regular political analysis is inadequate. We need to consider the Austrian and libertarian perspective. Austrian economics begins with a sobering view of incentives. People act and respond to knowledge and the information readily available to them. And institutions do not abolish human nature, they channel them. And the libertarian political critique adds that government is not an ordinary market participant. It does not merely persuade people to act. It regulates, it subsidizes, and it taxes. That means that broad political decisions can determine the direction, the movement, and the velocity of wealth. On the other hand, in a market economy, profit and loss helps guide and direct capital allocation. If you misread demand, you bear losses. If you create value, then you can make profit. But if you destroy value, then you lose profit. But the political economy acts differently. Costs are often diffused, buried, and forgotten, and policy benefits are often quite concentrated. The loser may not know why he lost, and the winner may not know why they won. And while policy can still be attempted to be written in the most neutral language, it can still produce dynamic results. And that's why conflict of interest rules are not merely decoration. They are one of the few institutional restraints between public accountability and private advantage. And when those restraints rely too heavily on internal screening, confidential arrangements, broad class exceptions, and an after the fact ethics review, citizens are being asked to trust a mechanism that they cannot meaningfully inspect. It is an inefficient standard for a free society. And the clearest current example is the Canada Strong Fund. The official materials call the Canada Strong Fund Canada's first wealth fund, initially seeded with a $25 billion contribution from the federal government. I have already discussed the facts and fallacies of the Canada Strong Fund in a prior video, so we're not going to go through those issues here today. What's important is this fund is specifically suggested as a private-public capital vehicle, and it will be aimed at strategic and specific sectors in the Canadian economy. And these sectors already overlap heavily with Brookfield's existing world. It's a complete misstatement that the Canada Strong Fund will invest in Brookfield directly. The issue is that Ottawa is creating a $25 billion sovereign wealth fund that's investing in the areas of the economy that Brookfield is already invested in. Now add Mark Carney. His public ethics appendix lists the divestment of his assets and interests in Brookfield and the 103 subsidiary companies. However, the ethics commissioner stated that it is clear that Mark Carney's financial future is directly tied to the success of Brookfield. But he also suggested that the blind trust and the conflict of interest screen was set up so that he wouldn't directly or indirectly knowingly benefit from these policy decisions. And that is the heart of the problem. How could you not know that you would directly or indirectly benefit? It's a serious conflict of interest that's hiding in plain sight. And that's exactly where the law's broad policy problems arise. If the Prime Minister were making a decision specifically about a company that was owned by Brookfield, then the conflict of interest screen could be triggered. If the government creates a broad national investment vehicle that's in the areas of energy, infrastructure, mining, transport, nuclear, LNG adjacent development, and nation building projects, the matter might be treated as general economic policy. As I mentioned before, public policy can create private concentrated benefit. Our system should be designed so that the public can see and sense and view the relationship between public policy and private interests before the money actually moves. And as I said before, this is not a new issue. Prime ministers govern through broad public policy, and that's the recurring error. So let's explore a few historical examples to demonstrate that this isn't limited to Mark Carney. Before becoming Prime Minister, Paul Martin was closely associated with the Canadian steamship lines. The Ethics Commissioner 2004-2005 annual report described a recusal process for Paul Martin that applied to cabinet meetings, briefings, matters, and other discussions with the Prime Minister where there was a specific and direct link to the business interests of the Canadian steamship lines. But it also stated that recusal was not necessary when it came to general matters of the Canadian steamship lines or of public policy. In the 2017 Trudeau report, Ethics Commissioner Mary Dawson found that Justin Trudeau contravened Sections 5, 11, 12, and 21 of the Conflict of Interest Act in relation to vacations on Bell's Quay the Aga Khan's private island. The report found that Trudeau contravened the gift rules and failed to recuse himself from discussions that furthered a private interest associated with one of the Aga Khan's institutions. He failed to arrange his private affairs to avoid that opportunity and accepted travel on a non-commercial airline without prior approval. That was not a blind trust case. That was a case about gifts, hospitality, and official dealings. And it also revealed that personal relationships and official capacity sometimes blur the lines. The 2019 Trudeau 2 report examined whether Prime Minister Trudeau used his position to influence the Attorney General's decision in relation to a criminal prosecution involving SNC-Lavalin. Ethics Commissioner Mario Dion found that Justin Trudeau had indeed contravened the act. The commissioner also found that SNC-Lavalin's private interests would have been furthered had that interference succeeded. This is a crucial point because it expands the conflict rules beyond stock holdings. Conflict of interest is not only about whether the Prime Minister owns a certain stock or investment security, but whether public power is being used to further private interests. The state has the power to coerce, so when the state uses that power, the citizen should ask who pays and who benefits, and who is exempt from the discipline that everyone else faces. The We Charity controversy adds yet another layer. In the Trudeau 3 report, the Ethics Commissioner found that Trudeau did not contravene subsection 6(1), section 7, or section 21 of the Act. But the report is still highly relevant because Trudeau has publicly acknowledged that he should have recused himself because of the appearance of conflict. A prime minister can acknowledge that he should have recused himself, and the law can still say there's no contravention. It doesn't mean that the commissioner was wrong. It just means that the statute may be too narrow or the bar may be set too low. The higher standard of politics is whether conduct by a publicly elected official can bear the scrutiny without degrading the trust in the institution of the state. This is not a Liberal-only problem. Under Stephen Harper, the Harper-Emerson affair raised a different kind of conflict concern. David Emerson had been a Liberal MP and then crossed the floor to join Harper's Conservative cabinet. The Ethics Commissioner investigated whether Harper offered an improper inducement. The commissioner found that neither Harper or Emerson were at fault of any conflict of interest or had broken any rules in the act. But the commissioner observed that people felt that their votes had been devalued, and that the case revealed a gap between the values underlying the members' code and the detailed rules within it. Some conduct may not break the rule, but still expose the inadequacy of it. In the Nigel Wright and Mike Duffy affair, the formal ethics finding was not against Harper personally. It was against Nigel Wright, Harper's chief of staff. The Wright report found that Wright contravened subsection 6(1) and section 9 of the Conflict of Interest Act in relation to his payment of more than $90,000 to Senator Duffy and his efforts to influence others to further Duffy's private interests. It is relevant because it shows that the Prime Minister's office itself can become the arena where political damage control, private financial benefit, public authority, and institutional accountability collide. The modern PMO is not merely a scheduling office. It is a concentration of political power, and wherever power concentrates, conflict risk concentrates too. For example, Brian Mulroney and Karl-Heinz Schreiber. The Oliphant Commission examined business and financial dealings between Prime Minister Mulroney and Schreiber, and the report found that Mulroney's failure to disclose those business and financial dealings was inappropriate. Then there's the sponsorship scandal under the Chrétien government. This was not a blind trust or personal investment case. It was a public money, political incentive, and institutional control case. The Library of Parliament's overview of the Montgomery Commission report described systemic problems identified by the Commission, including partisan political involvement in the sponsorship program, insufficient oversight by senior public servants, and deliberate actions to avoid compliance with federal legislation and policies. Some Montgomery findings against Chrétien personally were set aside on judicial review because of an apprehension of bias. So the proper use of the sponsorship scandal is not to overstate the findings against Chrétien. The proper use is institutional. But Canadians seem to repeat this problem between public power and private benefit that continue to be entangled. So when we return to Mark Carney and Brookfield, we shouldn't think about this as being an isolated or special case, but rather the current expression of the repeating Canadian problem. The Paul Martin case shows the weakness of the rules. Trudeau's Aga Khan case can show how personal relationships can diffuse or concentrate public power. SNC-Lavalin can show how undue influence can affect private interests. The We Charity report shows that conflicts of interest can fall outside of the substantive rules. The Harper-Emerson file shows that conduct can fall fully within the law, but still leave citizens feeling democratically betrayed. The Wright report shows how the PMO can become entangled with private financial benefits. The Mulrooney case shows that the ethical burden of high office often expands beyond narrow legality. And the sponsorship scandal shows that public money, party advantage, and weak controls can produce systemic failure. And Carney brings the issue to the present. Complex financial interests, a blind trust, a conflict screen, a broad class exception, and a public asked to trust that national policy will not produce private benefit in the way citizens cannot see. That is why this video should not be considered to be a Carney scandal issue. It should be considered a masterclass on the perception of Canadian governance. If the conflict of interest rules become too strict, they may discourage talented people from running for office. A country does not benefit if only career politicians, academics, or people with simple financial affairs run for office. The House Ethics Committee heard this concern. One view was that blind trusts and recusals allow people of wealth or significant business influence to run for office and participate in public life without the burden of disposing of all their assets. That is not a foolish argument. A serious country should not have to punish people for building things, acquired expertise, or acquired capital. Business experience can be a valuable lesson in public leadership. But the opposite danger is also true. A country cannot design an ethics system so permissive that the most powerful people in government shape policy and the people are told not to worry. That's only wearing a costume of trust. The challenge is not to exclude capable people. The challenge is to design rules capable enough to deal with capable people with complex financial interests. The system should not depend primarily on people with great personal character alone. It should also depend on institutional restraint. A free society assumes that its rulers are not angels, that they are human, and that is why power must be kept in check. Because it's about protecting public legitimacy. Because when the citizens conclude that politics is just a game run by the insiders, trust collapses. And when trust collapses, people withdraw from participating in the system. They become less civic-minded. They become cynical, and they radicalize. And a democracy cannot run indefinitely on cynicism. The core libertarian insight is this: the state is not merely another institution in society. It is the institution with legal coercive power. It can take your income before you receive it. It can regulate your business before you open it. It can dilute your currency without your permission. It can design rules to determine which industries and companies survive and which ones do not. That does not mean that every action taken by government is corrupt. But it does mean that every exercise of government power should face a higher level of justification. And when the people who are exercising power have complex financial interests involved in broad public policy, that burden of justification must be placed even higher. It's not up to the citizen to prove corruption. The system should automatically have to prove separation. The standard should be, can a reasonable citizen see, test, and observe, and challenge the relationship between public policy and private benefit? Not just trust me or the ethics commissioner approved it. So Mark Carney's business interests seem to have been accepted by Canada's ethics system. The deeper issue is whether a prime minister with such deep, complex financial interests in the overall system shape broad policy. And this should apply equally to all political parties. A serious democracy doesn't run around making rules specifically for the current person in office. It should write ethics rules that are objective for the office itself, because the office remains long after the person has departed. And if the rules are too weak, the Prime Minister inherits some sort of dangerous discretion. So the real scandal here is not that the rules were broken, but they worked exactly as they were written. And they still were not enough. And that is Canada's blind trust problem. It is a problem of political interests, incentives, institutional design, and public trust. It is the recurring failure to understand that legality is the floor and not the ceiling. The highest office in the country should not be held to the lowest defensible standards. It should be held to the standard held by free citizens to understand that power that's concentrated is rarely harmless. And in my view, Canada's conflict of interest system has not yet earned that kind of trust. If you enjoyed this video in your journey of discovery of financial literacy, politics, economics, history, and philosophy, make sure that you subscribe, like the video, hit the notification bell for upcoming videos.